Inside this chamber, European lawmakers have engineered the world's first comprehensive horizontal framework for artificial intelligence. The AI Act operates through a hierarchy of risk tiers. It separates algorithms into categories, from minimal and limited risk to high-risk systems and practices that are entirely prohibited. For high-risk systems, the Act mandates strict market placement rules, including data quality requirements and conformity assessments that must be completed before a product can launch. To enforce these rules, the regulation establishes a network of European and national authorities, tasked with market surveillance and oversight. Violations trigger administrative fines. These are punitive payments to the state, often calculated as a percentage of a corporation's global annual turnover. As a piece of administrative legislation, the AI Act is comprehensive, but its scope is limited to the relationship between a corporation and the state. There is a recurring assumption among technology executives that meeting the AI Act's compliance standards also provides a shield against civil lawsuits. Civil liability governs a different outcome: the legal obligation for a company to compensate an injured citizen or business for measurable harm. When a civil damage claim routes toward the AI Act, it finds no destination. The 2024 regulation contains no civil liability regime. It does not mandate compensation for victims, define the rules of fault, or govern financial accountability for damages. European lawmakers intentionally separated market safety rules from individual civil redress, leaving the question of who pays for harm to a different set of legal texts. To map your actual financial exposure, you have to look past the AI Act to the directives that govern the civil courts. Regulatory compliance is evidence of safety, but it is not a substitute for liability. In the European market, satisfying a regulator is not the same as satisfying a plaintiff. The financial mechanism that forces AI developers to pay for damages is the revised Product Liability Directive, or PLD, of 2024. The original 1985 directive was designed for physical goods, tangible, manufactured products like car tires or power tools. The 2024 revision updates this framework for the digital economy, specifically addressing the unique challenges of software-driven harm. The PLD legally reclassifies software and AI as products. Algorithmic code is pulled out of services and locked into the category of physical hardware. Traditional software licensing protections are replaced. As-is clauses no longer hold weight when software is legally a manufactured product. Under this directive, a generative AI model is now legally equivalent to a physical component in a car or a medical device. Reclassifying AI as a product triggers the application of strict liability to the provider. In a traditional negligence case, a plaintiff has to prove that a developer made a specific error or breached a duty of care during the coding process. Strict liability is a no-fault model. The equation requires only three elements: the product, a defect, and the resulting damage. An injured party only proves the AI was defective and caused their loss. They don't have to prove developer carelessness.
A defect occurs when the AI fails to provide the level of safety a user is entitled to expect, taking into account its intended purpose and the context of its deployment. This covers a broad range of harms, including physical injury, psychological damage, and the loss or corruption of professional data. Because the model focuses on the output and the harm rather than the developer's intent, the complexity of an AI's black box is not a defense against a claim for damages. Corporate risk in the European market is now anchored to one specific date on the legal timeline. That date is December 9, 2026. By this deadline, 27 member states must transpose the 2024 Product Liability Directive into national law. AI products placed on the market after this date fall under strict liability rules. Systems marketed before remain under the legacy 1985 framework. For operators, this creates a defined window to adjust safety engineering and risk management before the strict liability standard becomes the law of the land. Not every algorithmic harm involves a defective product. Some cases involve discrimination, privacy violations, or purely financial losses that fall outside the PLD's reach. The European Union originally planned a second piece of legislation to address these cases, the AI Liability Directive, or the AILD. This was designed to ease the burden of proof for victims of complex, non-product harms where the algorithm's inner workings remained opaque. However, in 2025,
the European Commission officially withdrew the proposed AI liability directive from their active legislative agenda. This withdrawal leaves a gap in the harmonized architecture for catching harms that don't qualify as product defects. Without this specialized directive, complex non-product harms are routed back into a much older layer of the legal system. When a claim falls through the gaps of the product liability directive, it lands in the bedrock of the legal system, national tort law. This bedrock is composed of the civil laws of the 27 individual member states. In this layer, the strict liability of the PLD typically disappears. National tort laws generally require a plaintiff to prove that the operator was at fault or negligent. This creates an unharmonized environment where the rules of evidence and the definition of a duty of care change whenever a claim crosses a national border. Escaping the PLD does not mean escaping accountability. It means defending your system in a fragmented landscape of 27 different national courts. Navigating the European market requires managing 3 distinct layers of legal reality. Layer 1 is the AI Act, which governs market entry, technical standards, and administrative fines. Layer 2 is the 2024 Product Liability Directive, which imposes strict financial liability for defective AI products starting in 2026. Layer 3 is national tort law, the fragmented safety net for every harm that doesn't fit a directive. Strategy must now move beyond compliance checklists. Leaders are being forced to shift from administrative box ticking to holistic liability engineering. In Europe, the AI Act gets your product through the door, but managing your exposure to civil liability is what protects the balance sheet.